the first thing is there's no reference to whether tax is owing or not. It just says taxpayers who identify the need to file delinquent information returns. Then it goes on to say should file the returns through normal filing procedures.
Just file them where they're supposed to be filed, right? 3520, send it out to Ogden in Utah, right? Whatever the instructions say. Should just file late. But
5471, just file it, right?
Just file it, right? And of course, your opening comment there, if there's unreported income, I don't care what it says, I would seriously consider a streamline to avoid some of the problems we're about to talk about.
I think that, streamline, if it's open to you, is always the way to get these information returns in, right? Okay. All right. So through normal filing procedures, and I think it's worth getting into our discussion here, the fact that some of these information returns are required to be filed, whether a tax return is required or not. I think the 3520s, the 5471s, for example, would be two examples of that, aren't they?
Yes, particularly the 3520. You have to file it separately from the return, goes to Ogden, Utah, and you file it whether or not you have a tax return obligation.
Right. Then they go on to say, and this is very different from a few months before. A few months before, you're required to file a reasonable cause statement. Now they're saying taxpayers may attach a reasonable cause statement. May. Then they go on to say that, well,
this is my favorite part.
You may attach it and we may read it or we may not, right?
That's my favorite part of it, right. Right, and I don't have it in front of me if you wanted to read the language off, but it's...
let me read the paragraph. I'll read the paragraph right into our discussion because I think it's interesting. I think it's significant. Taxpayers may attach a reasonable cause statement to each delinquent information return filed for which reasonable cause is being asserted. Okay. During processing of the delinquent information return, penalties may be assessed without considering the attached reasonable cause statement. It may be necessary to respond to specific correspondence and submit or resubmit reasonable cause information. Amazing paragraph. The word may is used 3 times.
Right. Look, I mean, to deconstruct this for listeners, what that essentially is acknowledging, in my opinion, is that initially it was supposed to work in a way where penalties were not automatically being asserted. And reasonable causes were supposed to be read, and it was supposed to be processed, and everything was supposed to be okay. But penalties were being issued. Reasonable causes were not being read. And in my opinion, after a lot of backlash from the tax professional community and probably the tax community at large, you have a situation where the IRS acknowledges, essentially with the 3520, a systemic issue, and is essentially changing things up and saying, look, we're no longer going to not assert a penalty up front and read your reasonable cause. You want to file a reasonable cause, file it. We may read it, we may not read it. We may open the mail, see the reasonable cause, take it off, put it in the shredder over there, and then take the return, process it through, assert a penalty, and then respond later and file an appeal later. That is significant, right? And what that does is it essentially creates a situation where if you're going to file a late 3520, you're almost certainly going to receive a penalty. And then you're thrown into getting a tax professional, fighting this, filing an appeal. You only got 30 days to respond, and you're going to respond with a letter to the campus to try to get them to undo this. But by the time the campus receives the letter, there's only 30 days to file an appeal. You're not going to hear back in time, so you're filing a protest. Now it's going to appeals. The campus perhaps lost jurisdiction of the case when you filed the protest and they forwarded it on. So now your first crack at it is with appeals. Appeals has this unicorn scenario for reasonable cause. Now you're $5,000 to $10,000 in on legal fees fighting all of this, and you're just a blue collar person, and you've got a family to raise and you've got a job to maintain, and maybe you're not making that much money. Maybe that's why you got the gift in the first place, because you're struggling financially and your parents are helping you out from abroad. And here you are in a whole world of hurt, spinning round and round you go, and it's an incredible challenge to deal with, and I'm incredibly sympathetic to people who go through this on a daily basis.
You know, I mean, I have talked to people who fit exactly those scenarios. I mean, I talked to somebody who got a $10,000 3520 penalty for not reporting what's in Canada called a TFSA with very little money in it. And he called me to ask whether he should take the $10,000 out of his line of credit to pay it, the student line of credit. Can you imagine?
Yeah, I've received those exact same phone calls as well. Right, it's my education money. Should I take the money that was dedicated to my education and pay penalties associated with non-compliance? I mean, these types of questions are, it's food out of people's mouths. It's money they don't have. And although
they're trying to comply. That's what's amazing, right?
And the IRS is looking at it like, you got this money, you've got money to pay, but maybe they got the money because they were struggling. Maybe they needed to buy a house and parents were helping out with the down payment or construction costs. And now, now what, they're going to refinance the house? They couldn't afford it to begin with, right? And it's wild what's going on out there. I don't know that the IRS intends for this to be happening. I think it's a huge bureaucracy, and there's a lot of moving parts within the IRS, and we're trying to gain the attention of the right people, and largely, I think the IRS is receptive to change here, but change doesn't happen fast.
For taxpayers with unfiled international information returns, the best approach is to carefully evaluate the options for coming into compliance at Eli Noff of Frost law. For instance, in light of the IRS approach to reasonable cause regarding international information return penalties, the streamlined filing compliance procedures, when available to non-willful taxpayers who have both unreported foreign source income and delinquent forms, might provide the best option. When I read that, I mean, I think you're absolutely right, and you put it very, very well. But if I were somebody with this problem reading that, I would say, oh my God, I hope I have some unreported income.
I don't disagree with you. And the sentiment's exactly right. Meaning the way the landscape is currently, because of what we just talked about in the delinquent submission procedures for 3520s that are late, there's pretty much a guaranteed penalty. And a lot of times you walk through taxpayers' landscape of compliance options, such as the streamline, and it's, wow, I wish I had unreported income to be able to utilize that procedure. And it's almost like you're scratching your head. You're like, what? I want unreported income. And you look at it and you're thinking to yourself, gosh, there's a disconnect here, and the policies and procedures could be better so that taxpayers aren't, left scratching their heads and kind of counterintuitively looking for unreported income. That's what they want to find, to be able to be eligible for a procedure that takes a more, organized approach or systemic approach to coming to compliance, and is really evaluating these streamlined procedures, a lot more carefully than the delinquent submission, where they're acknowledging, send a reasonable cause, maybe we'll read it, maybe we won't, right? And I think that's where it's tough. And now, unfortunately, when you're getting a gift and there's no unreported income associated with it, you really don't have a lot of options, right?
Yeah, it's terrible, but this applies beyond the 3520. I mean, it would apply for a very common area in Canada would be the people who have these TFSAs, which are essentially bank accounts with a tax wrapper where the interest, whatever, is not taxed by the Canadian government, but of course it is taxable if you're a U.S. citizen. So you could use the streamlined procedure in that case, right? It just seems to me that when you read these things together, you have a situation where, in certain cases, people who have reported every cent, lifted up the cushions on their sofa, whatever, are treated worse than people who haven't.
Right. I mean, look, it's tough to justify why things are the way they are right now in terms of the compliance landscape. But it really does put a taxpayer with late 3520s into quite a dilemma. And, look, we discharge our ethical obligations and we notify our clients that what their obligations are and what they have to do to file. But invariably, they always ask, well, what are the penalties associated with it? And I'm already 5 months late, and now the penalties are already at a maximum, and the landscape currently is unfavorable, and to come into compliance, and those types of discussions. And those are really tough discussions to have with clients, and try to steer them to do the right thing, where there's a situation where they're going to be high likelihood they're going to receive that penalty notice in the mail.
Well, to quote from this article again, another area where they're referring to you, they're drawing on your thoughts. We have this paragraph that says, part of the difficulty that taxpayers encounter in seeking abatement for reasonable cause is the lack of favorable case law on reasonable cause in the international information reporting penalty arena. Noff said, of the few, and I think this is important, of the few cases out there, some had egregious facts compared to the typical non-filer of Form 3520, he said. The result is that appeals is less likely to tip the hazards of litigation scale in taxpayers' direction and tends to take a harsh approach to reasonable cause. So basically, we're in a situation where, agree with me, disagree. All these people want to come into compliance. The IRS won't let them.
I'll say a little differently. I'll say the IRS will certainly let them come into compliance, file the late returns, but the landscape, the way it is a disincentive to come into compliance, right? So when you're coming to compliance, it's, well, what benefit do I get from it? Meaning the voluntary nature of my compliance is what lenient approach will the IRS take with me? And the answer is currently with these late 3520s is none that I know of, meaning you're filing, the government's acknowledging they may not even read the reasonable cause. And then you're going to appeals and you're seeing what's happening there with the reasonable cause determination. And, you tell your client, really it's going to be a reasonable cause fight. And the government's looking at it very narrowly. So they look at it and they say, well, I thought voluntary compliance is supposed to provide, especially when you're correcting non-compliance, is supposed to give you some type of benefit. I mean, even look at, just thinking about this top of my head, look at the criminal voluntary disclosure program, right? Even criminals coming into the voluntary disclosure program, if they come voluntarily, are getting concessions, whether it's, accuracy related penalty concessions or fraud penalty concessions on many of the years, informational reporting concessions. They're only getting a 50% FBAR penalty versus all the other informational reporting penalties, right? Only 50%. I don't mean to say it that way, but the point is that even criminals are getting some concessions. Streamlined, you're getting concessions, right? And here you are with a late 3520 with no tax due, and what's the concession, right? You're being held to a.
So you inherited a piece of real estate from your relative in Italy. I had no idea you had to report it. No concession for you.
Essentially, unless you have the unicorn reasonable cause, maybe, right? But ignorance, which is a lot of what we see is ignorance. People that are coming to the U.S. and don't understand the tax system and are using TurboTax, right? And there's no question about foreign gifts, and they didn't know that it had anything. Why would a gift be reportable? Why would that be taxable? And they don't look.
Yeah,
they don't check.
absolutely.
And they don't know. Absolutely. Or they check and they come to the wrong conclusion. The government says, no, if you would have looked at this page, line 17 on page 42, it was right there. And it's just so unreasonable. And I would love to see them really take a more reasonable approach.
Right. And I know you've been working hard to get them to do that. On that note, I think we can probably bring this to an end, at least for now. I wonder, though, I'd like to give you the opportunity again to give people your coordinates. Certainly anybody who's listened to this, I think, will be very, very comfortable with the knowledge and expertise that you have.
I appreciate that. And of course, feel free to reach out to me. My direct phone number in the U.S. is 410-702-5010, 410-702-5010, and you can find me online at www.frost, F-R-O-S-T, taxlaw.com.
Great work. You're an evangelist. All right. Well, thank you so much for taking the time to discuss this with me today. Until next time.